Case 1. Twyena Thomas. September 30th, 2017. 8:22 p.m. Kenner, Louisiana. A 911 call comes in from an apartment on 31st Street. A mother reports her toddler isn't breathing. Officer Alexander Corey Monson arrives within 5 minutes. Paramedic Rogelio Lopez from East Jefferson Hospital rushes inside. What they find will haunt them forever. Chase Thomas, 28 months old. No pulse. Not breathing. Body temperature already matching the room. He weighs 15 pounds, half what a child his age should weigh. Standard 2-year-olds weigh between 28 and 30 pounds. Chase weighs as much as a newborn who's a few months old. 8:40 p.m. Chase is pronounced dead at East Jefferson Hospital. His mother, Twyena Thomas, 27 years old and pregnant with her 5th child, is arrested that same night. Cruelty to juveniles. But this is just the beginning. 2 days later, October 2nd, the Jefferson Parish coroner completes the autopsy. Dr. Jerry Kvitanovich has seen a lot in his career. This stops him cold. He calls it the worst case he's ever seen. Multiple blunt force trauma to the head, torso, extremities. Brain hemorrhage. Evidence of prolonged starvation and abuse. The charges are upgraded. Second-degree murder. January 25, 2018. A grand jury indicts Twyena Thomas. Now let's go back. Who is Twyena Thomas? She's originally from New Roads, Louisiana. At 27, she already has 4 children with a 5th on the way. But her history with those children tells a disturbing story. October 2011. New Orleans, Algiers neighborhood. 3 a.m. Police find her 3-year-old daughter wandering the streets alone. Thomas is arrested for child desertion. But there's more. Court records reveal something even more specific. October 15, 2015. Chase Thomas, this same child who would die 2 years later, is just an infant. Twyena Thomas commits an act of cruelty against him. It's documented. It's on record. The pattern was there. The warning signs were there. Crime scene technician Sean Carl Carson processes the apartment. Blood everywhere. Living room walls. Bedroom walls. Soiled rags. Behind the toilet. Field tests come back positive. DNA analyst Marcella Zozaya from the Jefferson Parish Crime Lab confirms it all matches Chase. Thomas admits to investigators she was Chase's sole caregiver. She admits she hit him with a slipper on several occasions. She admits she used cloth material to restrain him when he was misbehaving. And here's the cruelty that goes beyond physical abuse. While Chase was starving, Thomas was posting photos of her meals on social media. Sloppy joes. Eggs. Sausage. Grits. She was eating. He was dying. The trial begins before Judge Danielle Taylor in the 24th Judicial District Court. 3 days. Assistant District Attorneys Matthew Whitworth and Jennifer Voss present the case. This isn't just murder. This is child torture. Psychological abuse. Emotional abuse. Physical abuse. Starvation. Everything a mother could do to destroy a child, Twyena Thomas did to Chase. August 22, 2019. The jury deliberates. How long does it take them to reach a verdict? 30 minutes. Unanimous. Guilty of second-degree murder. September 30th, 2019. Exactly 2 years after Chase died. Sentencing day. Judge Taylor doesn't hold back. She imposes the mandatory sentence, life imprisonment without parole. Then she says something that cuts through the courtroom. Chase died alone in his room, scared not of the imaginary monster in his closet, but you. You were the monster. Thomas speaks just once. 5 words. Chase didn't deserve that. No, he didn't. Thomas appeals. She challenges the admissibility of the 2015 Prior Act evidence, that earlier incident of cruelty when Chase was an infant. July 29, 2020. The Louisiana 5th Circuit Court of Appeal affirms the conviction and sentence. Case number 19-KA-582. The appeals court agrees with everything. The conviction stands. The sentence stands. Today, Twyena Thomas remains incarcerated in the Louisiana Department of Corrections. No possibility of parole. Ever. Chase Thomas was 28 months old. He weighed 15 pounds. He died scared and alone. And his mother, the person who should have protected him, was the one who killed him. Case 2, Diane Ferrand. April 27, 2022. New Orleans. Inside a residence, something terrible happens to 2-year-old Galen Ferrand. The next afternoon, 4:50 p.m. on April 28th, the NOPD Child Abuse Unit gets the call. Suspected physical abuse. Diane Ferrand, 25 years old and mother to multiple children, is booked on second-degree cruelty to juvenile charges. Then everything escalates. May 1st, 2022. Galen dies at Children's Hospital. The Orleans Parish coroner rules it a homicide. Cause: blunt force trauma. Ferrand is rebooked. Second-degree murder. Combined bond for $100,000. But here's where this case gets complicated. Because while what happened to Galen is horrific and unforgivable, the people around Diane Ferrand are struggling to reconcile the woman they knew with the crime she committed. Her defense attorney will later describe her as someone who endured a lack of emotional and other support while raising her children. Someone who became overwhelmed. Family members report she'd been struggling with serious problems. She'd made suicidal threats to Galen's father. This is a woman in crisis. And a child paid the price. Family members report what Ferrand told them. She assaulted Galen because he wouldn't put on his socks and had peed in the bed. Think about that. A 2-year-old had an accident and wouldn't cooperate with getting dressed, normal toddler behavior, and his mother's response was catastrophic violence. After the assault, she placed him in bed next to his brother. And then she waited. 16 hours. 16 hours before calling for help. Eventually, a family friend made the 911 call after Ferrand found the child unresponsive. Medical documentation tells the story of what happened to Galen in clinical detail. Multiple lacerations on his head, missing fingernails, burn marks across his body, multiple bruises. When medical staff evaluated him, they determined he was brain dead. This 2-year-old child had suffered injuries so severe that his brain could no longer function. The case moves toward trial. Ferrand is facing second-degree murder, but she offers a different path, a guilty plea to manslaughter. Prosecutors accept. ADA Zachary Creel characterizes the plea as her desire to do penance for a crime that is unforgivable. He says Ferrand committed crimes against humanity and crimes against nature. March 1st, 2024. Judge Marcus DeLarge presides over sentencing. 40 years in prison. But then something unusual happens. The judge offers words that suggest the possibility, not certainty, but possibility, of redemption. You made a bad decision, but that doesn't reflect on the type of person you are, or even the person you can still become. And then comes the most remarkable moment of the proceeding. Twyena Washington, Galen's aunt, sister-in-law to Diane Ferrand, stands to give her victim impact statement. She doesn't curse Ferrand. She doesn't demand maximum punishment. Instead, she offers something unexpected: understanding. As a mother, I fully know, it's not your fault. I understand. How do we make sense of that? A family member, related to the victim, offering support to the perpetrator? It speaks to something complex about this case. About mental health. About support systems that fail. About the breaking point when overwhelmed parents make choices that can never be undone. None of this excuses what happened to Galen. Nothing could. A 2-year-old is dead because his mother assaulted him over socks in a wet bed, then waited 16 hours to get help. But it does illustrate something important about these cases. They're not always simple stories of evil. Sometimes they're tragedies layered on top of tragedies. Diane Ferrand is currently serving her 40-year sentence in the Louisiana Department of Corrections. Under Louisiana law, she may become eligible for parole consideration after serving a portion of her sentence, subject to good behavior credits and parole board decisions. No appeals have been publicly recorded. She'll have decades behind bars to think about 16 hours that changed everything. 16 hours that killed her son. 16 hours that ended her life as she knew it. 16 hours that never should have happened. Case 3. Cynthia Perkins. October 23, 2019. 2 coordinated arrests executed simultaneously across Louisiana. Cynthia Perkins, 34-year-old English teacher at Westside Junior High School, arrested at her home in Denham Springs. Her husband Dennis Perkins, SWAT commander for the Livingston Parish Sheriff's Office, arrested near a fishing camp in Toledo Bend in Sabine Parish. That same day, Cynthia resigns her teaching position. What investigators found will send shockwaves through Livingston Parish and far beyond. Let's go back to July 2019. The National Center for Missing and Exploited Children receives a cyber tip. Illegal material involving minors. By October, Investigators traced the IP address to the Denham Springs residence shared by Cynthia and Dennis Perkins. What they discover there is almost incomprehensible. Over 2,600 photographs, over 300 videos, more than 5 terabytes of encrypted data pulled from various electronic devices. Hidden cameras, one concealed inside a soap dispenser in the guest shower, another hidden in an artificial plant in the bedroom. A spy watch used for recording. Between 700,000 and 800,000 digital files processed during discovery. The investigation is massive. Louisiana Attorney General's Office, Louisiana Bureau of Investigation, FBI, Louisiana State Police, all working together. What started with a single cyber tip expands into something that eventually results in 72 counts against Cynthia Perkins alone. Who is Cynthia Perkins? On the surface, she's a respected educator. She started working for Livingston Parish Public Schools in 2009 as a substitute teacher. She advanced through positions at North Live Oak Elementary and Live Oak Middle School before transferring to Westside Junior High in 2016. She has 3 children from a previous marriage. She married Dennis approximately 1 year before their arrests. But that surface conceals a double life that investigators pieced together from the digital evidence. 60 counts of producing child sexual abuse material involving a juvenile under 13. 2 counts of first-degree rape, sexual battery, video voyeurism, mingling harmful substances. December 2019. Cynthia files for divorce from Dennis, claiming he made sufficient threats that render her fearful of him. Whether this is genuine fear or a legal strategy to distance herself from his crimes becomes a question the courts will never fully resolve. February 14, 2022. Valentine's Day. Cynthia Perkins accepts a plea agreement. She pleads guilty to 1 count of second-degree rape, 1 count of production of child sexual abuse material, 1 count of conspiracy of mingling harmful substances. The plea requires specific admissions. She assisted her husband in sexual assault of a juvenile. She helped film a juvenile while bathing. And here's something that horrifies the community in a different way. She laced desserts with bodily fluids and distributed them to school-aged children. Think about that. Parents sent their children to school. Those children trusted their teacher. And that teacher gave them contaminated food as part of some unfathomable criminal conduct. The violation goes beyond the specific victims. It extends to every parent, every student, every family who trusted this woman. February 18, 2022. Judge Erica Sledge imposes sentence. 41 years at hard labor. 40 years for second-degree rape, running concurrent with 30 years for production of child sexual abuse material, plus 1 additional year consecutive for the mingling conspiracy. Perkins must register as a sex offender for life. She waives all rights to appeal. At sentencing, Perkins apologizes to her family and former students. I would also like to apologize to my 3 children. I haven't spoken to them in 3 years. I love them and I miss them, and I'm sorry. One of her own children submitted a letter to the court. The letter describes Perkins as a horrible and manipulative mother. The child writes, "My life is so much better without you." When your own child tells the court their life improved after you went to prison, that tells you something about who you really were behind closed doors. Cynthia Perkins is currently incarcerated in the Louisiana Department of Corrections. She will not be eligible for parole until entering her 41st year of sentence, approximately 2060. By that time, she'll be in her 70s. Her ex-husband Dennis pleaded guilty on January 3, 2023, and received 100 years without parole. The Livingston Parish community is still processing what happened. The teachers who worked alongside Cynthia Perkins, the parents who trusted her with their children, the students who sat in her English class never knowing what she was doing outside school, the hidden cameras, the encrypted files, the double life. All of it happening while she graded papers and taught grammar and presented herself as a professional educator. Case 4, Dineshia Yates. February 12, 2024. 3:45 a.m. Baton Rouge, Louisiana. A 911 call comes from a residence in the 3300 block of O'Neill Lane. The caller is a juvenile. The caller reports a 3-year-old isn't breathing. The caller states there are no adults in the home. The caller doesn't know the address. East Baton Rouge Parish Sheriff's deputies canvass the neighborhood trying to locate the residence. They finally find it. And just as they arrive, Two women pull into the driveway. Dineshia Yates, 26 years old. Terica Scott. Both women immediately state they had just left the casino. First responders find 3-year-old Blessing Buckles unresponsive. Medics resuscitate her and transport her to the hospital. 2 days later, February 14th, she dies from a brain hemorrhage. Investigators start piecing together what happened. 8 children were in that house. 8 children ranging in age from 11 months to 12 years. All of them left unsupervised for several hours while the adults were gambling. And this wasn't the first time. Both women admit they regularly left the children unsupervised while they went to casinos. 2 juvenile males are identified as having inflicted the fatal injuries. A 10-year-old and a 12-year-old. Scott's son and nephew. But here's the critical detail. Both women had previously observed bruises on children after leaving them with the 12-year-old nephew. They knew he exhibited violent behavior. They knew children were getting hurt. Dineshia Yates ignored her children's pleas for help despite evidence of ongoing abuse. And she kept leaving them anyway because she wanted to gamble. Sheriff Sid Gautreaux makes a statement. A case like this is devastating. My heart breaks for this child lost too soon. Who is Dineshia Yates? She has multiple prior arrests for theft and property damage. October 2023, just 4 months before her daughter died. She's accused of robbing a man she met at a Baton Rouge casino blackjack table. After posting bond following her February 2024 arrest for her daughter's death, she's arrested again in March 2024 on new theft charges. The pattern is clear. The priorities are clear. Originally charged with principal to second-degree murder, Yates enters what's called a best interest guilty plea on April 10, 2025. She pleads guilty to manslaughter and cruelty to juveniles. Judge Colette Greggs imposes sentence. 15 years with all but 18 months suspended. Plus 18 months concurrent for cruelty charges. Plus 2 years probation following release. Co-defendant Terica Scott gets probation only. 5 years supervised with requirements to pay fines and complete parenting classes. The 2 juvenile defendants are charged with second-degree murder and booked into East Baton Rouge Juvenile Detention Center. Their proceedings remain confidential. Yates is currently serving her 18-month sentence with projected release in late 2026. The surviving 1-year-old, King Trail, was placed in state custody through DCFS. Let's talk about what this case represents. This isn't about a moment of rage. This isn't about someone who snapped under pressure. This is about calculated, repeated neglect driven by addiction to gambling. Multiple trips to the casino. Multiple instances of leaving 8 children alone with juveniles known to be violent. Multiple warnings ignored. And when those warnings escalated to injuries, bruises that both mothers could see, they still went back to the casino. Blessing Buckles was 3 years old. She died from a brain hemorrhage inflicted by other children while her mother was gambling. She died because the adults who should have protected her valued slot machines and card tables more than child safety. And she died alongside 7 other children who could have died just as easily, including the 11-month-old baby who couldn't even walk yet. The 18-month sentence feels light. But Louisiana's criminal justice system has to balance multiple factors. The fact that Yates didn't personally inflict the fatal injuries, the role of the juvenile perpetrators, the practical limitations of prison resources, and the possibility, however slim, that someone who makes these choices might change. Whether Dineshia Yates will change during her 18 months behind bars remains to be seen. Whether she'll be able to rebuild any relationship with her surviving children remains to be seen. Whether she'll return to the casinos after her release remains to be seen. What we know for certain is that Blessing Buckles will never see her 4th birthday, will never start kindergarten, will never grow up, because her mother wanted to gamble. Case 5, Satonia Small, January 2008. Shreveport, Louisiana. Southern Village Apartments. Fire breaks out while Satonia Small, 35 years old, is away with friends. A neighbor contacts a relative to report the blaze. A passing Shreveport police officer, Marcus Hines, stops at the scene and calls the fire department. Neighbor Terrence Jackson discovers Small's 7-year-old son outside. He knows there's a girl inside. He tries to rescue her. He tries to kick in the front door. It's locked. Flames are rising. Officers Hines and Stephen Plunkett also attempt to breach the door. They can't get through. When firefighters finally break through, The apartment is filled with smoke floor to ceiling. Part of the roof caves in during the search. In a back bedroom, firefighters find the limp body of 6-year-old Shajabern Small. Satonia Small returns home wearing gold-colored going-out clothes, visibly intoxicated. She's arrested at the scene. Shajabern is transported to the hospital on life support. January 25, 2008. She dies. But this case is complicated by history. December 2006, just over a year before the fire, Satonia Small was charged with criminal abandonment for leaving her children alone outside in 28-degree weather. May 2007. Her plea hearing. The judge asks if it will happen again. Small responds, "Never, never. I promise you that, because I learned a valuable lesson, because my kids is all I got." Less than a year later, she leaves them alone again. And one dies. August 2010. The Calcasieu Parish District Court Trial. The prosecution's theory. Small is guilty of second-degree felony murder because the death occurred during the commission of cruelty to juveniles. They play the full plea colloquy from her 2007 conviction for the jury. They show photographs of the apartment conditions. Unhealthy, deplorable, truly unbelievable conditions. The jury unanimously convicts Small of second-degree murder. Judge Mike Pittman imposes the mandatory life sentence without parole. But defense attorney Elton Ritchie had raised an important legal argument at trial. He said second-degree murder was excessive. This is a woman who merely left her children asleep and home alone. But we are going to punish her the same way we would punish a drive-by shooter? November 2011. The Louisiana Second Circuit Court of Appeals affirms the conviction. Case seems over. But it's not. October 2012. The Louisiana Supreme Court reverses the murder conviction. The High Court finds that the felony murder rule requires a direct act of killing by the defendant. Criminal negligence, absence and failure to supervise, does not constitute such a direct act. The Supreme Court enters a conviction for negligent homicide instead. 5-year sentence. Satonia Small had been incarcerated since 2008. With a 5-year sentence, she likely completed her time shortly after the Supreme Court ruling. This case raises fundamental questions about criminal law, about proportionality, about the difference between direct action and criminal negligence, about how we categorize responsibility when a mother's absence causes a child's death. Small didn't set the fire. She didn't intend for her daughter to die, but she violated her promise to the court. She left her children alone despite knowing the dangers. She was out drinking and enjoying herself while her children were unsupervised in an apartment with conditions so dangerous that prosecutors used photographs of them at trial. The Supreme Court decided that wasn't murder. That was negligent homicide. Some people agreed with that decision. Some people thought it was too lenient. Some people thought the original life sentence was appropriate regardless of the legal technicalities. These debates continue whenever the case comes up in legal circles. What's undebatable is this. Shajabern Small was 6 years old. Neighbors tried to save her. Police officers tried to save her. Firefighters tried to save her. The door was locked. They couldn't get through in time. She died on life support days later. And her mother was out drinking. The Supreme Court can classify the crime however the law requires. The sentence can be 5 years or 50 years. None of that changes what happened to Shajabern. None of that brings her back. Case 6. Hanna Nicole Barker. July 17, 2018. 9:10 p.m. Natchitoches, Louisiana. Hanna Barker calls 911 from her residence in Mayberry Trailer Park. She reports a kidnapping. She claims unknown attackers sprayed her with mace and took her 6-month-old son, Levi Cole Ellerby. 10:25 p.m. The Natchitoches Fire Department responds to a fire in a ditch off Breda Street, about 1 mile from Barker's residence. First responders find an infant. Levi Ellerby, second and third degree, burns over 90% of his body. He's rushed to a Shreveport hospital where he dies the following morning. Lieutenant Jeremy Swisher of the Louisiana State Fire Marshal's Office investigates. He quickly identifies problems with Barker's account. She provides 3 different names for the alleged attacker. There's no physical evidence of mace or pepper spray. No irritation on Barker. No lingering smell in the air. Swisher notes that Barker alternates between mad and screaming, but never actually cries. No tears. The case breaks when co-defendant Felicia Marie Nicole Smith, Barker's romantic partner, provides a detailed confession. Barker orchestrated the killing. They initially planned to shoot the child, but Smith's gun jammed. Forensic examination later confirms the gun jam. Barker suggested burning instead to leave no evidence. She believed the body would be bones before anyone discovered it. IHOP surveillance video confirms meetings between Barker and Smith. Phone records corroborate Smith's account. The kidnapping story falls apart completely. Barker is originally charged with first-degree murder. She maintains her innocence. But on May 4, 2022, she enters an Alford plea to manslaughter and conspiracy to commit first-degree murder of a child younger than 12. An Alford plea allows a defendant to accept conviction while maintaining innocence, essentially saying I didn't do this, but I acknowledge the evidence would likely convict me. Judge Desiree Diaz sentences Barker to 30 years, sentences running concurrent. District Attorney Billy Joe Harrington states, "We could not allow the mother, who planned to have her baby killed, to not be held responsible for her actions." Smith pleads guilty to multiple charges and receives 80 years consecutive without parole. As of 2023 reports, Barker was incarcerated at the Louisiana Transition Center for Women in Tallulah. An independent attorney estimated at sentencing that she could serve approximately 6 years with participation in enrichment programs, suggesting potential release between 2024 and 2026. Special Prosecutor Clifford Strider called this one of the most heinous and callous acts of cruelty he had ever seen. A mother planning the death of her 6-month-old infant, enlisting her girlfriend to carry it out, first attempting to shoot the baby. When that failed, burning him alive, then staging an elaborate kidnapping story complete with fake mace attack, and maintaining that story even as investigators presented evidence proving it was impossible. Levi Cole Ellerby was 6 months old, 90% of his body covered in second- and third-degree burns. He died in a Shreveport hospital after being found in a ditch that his own mother had her girlfriend set on fire. He never got to celebrate his first birthday, never got to take his first steps, never got to say his first words, because his mother wanted him dead. The Alford plea means Barker maintains she didn't do it. The 30-year sentence with possibility of release after 6 years means the criminal justice system valued other factors, her cooperation, the role of the co-defendant, prison overcrowding, whatever calculations prosecutors and judges make in these situations. Whether that's justice is something every person has to decide for themselves. What's certain is that Levi is gone, and nothing, no sentence, no punishment, no legal proceeding, changes that. Case 7, Sonia Charles. January 24, 1994. Jeanerette, Louisiana. Bob's Car Washington owner Alderman Bob Fontenot empties trash. In a 55-gallon barrel, he discovers the body of a newborn female. 6 pounds. Umbilical cord and placenta still attached. Born just hours before. Found with her thumb in her mouth. The community responds with grief and compassion. January 29, 1994. A community funeral draws over 200 mourners for a baby no one knew. She's buried as Baby Jane Doe. Iberia Parish Coroner Dr. James Falterman determines cause of death, hypothermia. The infant was alive when placed in the trash. She died from cold exposure as temperatures that night dropped into the 40s. She died slowly. She died alone. She died while her thumb was in her mouth. The Jeanerette Police Department preserves evidence. Years pass. The case goes cold. 2018, 24 years later, the case reopens after the Justice for Unsolved Murder Victims Project publishes flyers seeking information. September 2019. Nancy Grace features the case on her Crime Stories podcast. Detective Scott Hoddard of the Iberia Parish Sheriff's Office Cold Case Unit leads the renewed investigation. The Acadiana Criminalistics Laboratory re-examines the preserved evidence. They develop a DNA profile. A match through CODIS, the Combined DNA Index System, leads to a family relation, and ultimately to Sonia Charles. September 25, 2019. Sonia Charles, now 50 years old, resident of New Iberia, is arrested and charged with first-degree murder. She was approximately 25 at the time of the infant's death 25 years earlier. April 30, 2021. An Iberia Parish grand jury indicts Charles on 1 count of second-degree murder, downgraded from the original first-degree charge. Her bond is increased from $125,000 to $250,000. Charles bonds out. She awaits trial. The case remains pending in the 16th Judicial District Court. If convicted of second-degree murder, she faces mandatory life imprisonment without parole. This case represents something unique among our 10 cases. 25 years. A quarter-century between the crime and the arrest. Baby Jane Doe was buried in 1994 by a community that didn't know her name. DNA technology that didn't exist in useful form in 1994 solved the case in 2019. The 200 mourners who attended that funeral in 1994 didn't know they were burying the child of someone who lived nearby. They didn't know that decades later, science would give that baby her identity back, or at least identify her mother. They just knew an infant had died alone in a trash barrel, and they wanted to acknowledge her life, however brief. Sonia Charles lived 25 years after placing her newborn in that trash barrel. She built a life. She went about her business in New Iberia. Maybe she thought about the baby sometimes. Maybe she tried not to. Maybe she thought she'd gotten away with it. Maybe she lived in constant fear of discovery. We don't know. What we know is that DNA doesn't forget. Evidence preservation matters. And cold cases can warm up when the right technology meets dedicated investigators. The case has received national attention, including coverage on Dateline NBC. But for all the attention, the fundamental facts remain simple. A newborn was alive when placed in a trash barrel. She died from hypothermia with her thumb in her mouth. 25 years later, her mother was identified and charged. And now the courts will determine what justice looks like for a crime committed in 1994 prosecuted in 2025. Case 8, Aaliyah Jack. July 6, 2024. Aaliyah Jack, 25 years old, takes her 2 sons from their maternal grandmother following a family gathering in Lafayette. Legend, for years old. King Trail, 1 year old. It's the last time the grandmother sees both boys alive. July 8, 3 p.m. A passerby reports a body in the water behind the Vinton Welcome Center near the Louisiana-Texas border. Calcasieu Parish Sheriff's Office Marine Division recovers the body. Legend Jack, for years old. That evening, a warrant is issued for Aaliyah Jack's arrest. She's located at a train station in Meridian, Mississippi, approximately 350 miles from Vinton, attempting to board a train. She's arrested. But there's another child. 1-year-old King Trail is still missing. Tuesday, July 9th. Morning. Truck driver Reginald Walton, working for DHL Supply Chain, discovers 1-year-old King Trail crawling near an Interstate 10 embankment approximately 8 miles from where his brother's body was found. Think about this. A 1-year-old survived approximately 2 days exposed to tropical storm barrel conditions. Numerous insect bites, but otherwise in good condition. Sheriff Stitch Guillory calls him a miracle baby. That's not hyperbole. That's an accurate description of a 1-year-old surviving alone near an interstate for 2 days in storm conditions. July 20th, 2024. During extradition, Jack confesses to KPLC reporter, "I did that to them." She admits she was under the influence of drugs at the time. Jack's family provides background. She had fallen on hard times. April 2024. She fled to Baton Rouge, prompting family intervention. May 2024. Both children had been living with their grandparents after Jack gave up custody. She stated she was going to live her best life. She had no prior criminal record. Jack faces second-degree murder, cruelty to juvenile, and 2 counts of failure to report a missing child. Judge Tony Fazio sets bond at $9.1 million. September 10th, 2024. Jack enters a not guilty plea. A pretrial conference was scheduled for January 2025. Jack remains incarcerated at Calcasieu Correctional Center. The surviving child King Trail was released from the hospital after 1 night and placed in DCFS custody. Autopsy results for Legend have not been publicly released. If convicted of second-degree murder, Jack faces mandatory life imprisonment without parole. This case has everything that makes these stories heartbreaking and infuriating. A mother who gave up her children to grandparents so she could live her best life. A family that stepped in to raise those children. A mother who took them back for 1 weekend. A 4-year-old found dead in water behind a welcome center. A 1-year-old found crawling near an interstate after 2 days alone during a tropical storm. An arrest at a train station 350 miles away. A confession about being under the influence of drugs. $9.1 million bond. Legend Jack was 4 years old. Whatever happened to him in those final hours? He was alone with a mother who admitted being on drugs. His little brother Kingtrail was 1 year old, couldn't walk well, couldn't talk, couldn't seek help, and survived 2 days alone through sheer chance and the intervention of a truck driver who happened to see him. The family that tried to protect these children by taking custody must be living with unimaginable guilt and grief. They knew Aaliyah Jack was struggling. They took the children. They were raising them. And then she took them for one visit. Just one. And legend died. The trial will answer legal questions about guilt and punishment. But it won't answer the human questions. Why did she take them if she wanted to live her best life without them? What was she on when she killed Legend? How did Kingtrail survive? What will Kingtrail remember when he's old enough to ask questions? Who will raise him now? $9.1 million bond ensures Aaliyah Jack stays in jail until trial. The not guilty plea sets up a trial that will force a jury to decide what happened during those crucial hours. And somewhere, a 1-year-old who should have died but didn't is growing up without his brother and without his mother, protected by the state that failed to protect him from her in the first place. Case 9, Kayla Giles. September 8, 2018. Walmart parking lot, Coliseum Boulevard, Alexandria, Louisiana. A custody exchange. Kayla Giles, 33 years old, is meeting her ex-husband Thomas Cootie Jr. to exchange custody of their 2-year-old daughter. 3 children present, including older daughters from Giles's previous relationship. A shot rings out. Thomas Cootie Jr. falls. Shot in the chest. Kayla Giles is arrested at the scene. The couple married in 2014. Separated during contentious divorce proceedings in 2018. Court records reveal multiple domestic violence reports Cootie filed against Giles. August 8, 2018, 1 month before the shooting. He reports she brought a gun to a previous custody exchange. May 22, 2018. He reports she slapped him, causing a black eye. September 5, 2018. He reports she stole $5,200 from his bank account. 3 days later, he's dead. The prosecution's case hinges on digital evidence. After the shooting, Giles gave her laptop to her sister in a flour bag. Her sister transported it to Jefferson Parish to give to a friend. Obstruction of justice. But before that laptop disappeared, it told a story. August 24, 2018. Searches for Louisiana self-defense spouse and Louisiana self-defense laws. August 26. Searches for arrested after self-defense and self-defense in sidecar. August 27th. Search for Dallas Ruger .380, the firearm she used. September 4th. Search for relocation and restraining order. The prosecution argues this shows premeditation. Giles researched self-defense laws, researched the gun, bought the gun, took out insurance, then shot her ex-husband during a custody exchange and claimed self-defense. The Rapides Parish District Attorney recuses his office due to a prior business relationship with Cootie's father. The Louisiana Attorney General's office prosecutes. 9-day trial. January 29, 2022. Giles's 35th birthday. The jury finds her guilty of second-degree murder and obstruction of justice. Judge Greg Beard sentences her to life, plus 30 years consecutive. He notes he observed no emotion at all from Giles throughout trial. Case over, right? Wrong. June 27, 2025. The Louisiana Supreme Court vacates and reverses the murder conviction. The High Court finds reversible error in jury instructions regarding Louisiana's Stand Your Ground law. The court rules the jury was erroneously instructed they could disregard the self-defense claim if they found Giles was the aggressor. But no evidence was presented that she was the aggressor. That instruction was legal error. Reversible error. The murder conviction is vacated. The case becomes eligible for retrial. The obstruction conviction is remanded for reconsideration of whether the 30-year sentence was excessive. Giles's new attorneys hope to persuade prosecutors not to retry the case. So where does this leave us? Thomas Cootie Jr. is still dead, shot in a Walmart parking lot during a custody exchange. 3 children witnessed their father die. Kayla Giles spent years in prison for murder before the Supreme Court said the jury was instructed incorrectly. If you're the prosecution, you see internet searches proving she planned this. You see a history of domestic violence reports he filed against her. You see her bringing a gun to a previous exchange. You see her researching self-defense laws weeks before the shooting. You see her attempting to hide the laptop. This is premeditated murder disguised as self-defense. If you're the defense, you see a contentious divorce. You see domestic violence that may have gone both directions. You see a woman researching her legal rights. You see a shooting that occurred during a custody exchange, a high-stress situation where people feel threatened. You see Louisiana's stand-your-ground law that allows self-defense without duty to retreat. You see a jury that was given improper instructions. The Supreme Court didn't say Giles is innocent. They said the trial was legally flawed. Those are different things. Prosecutors can retry her. They have the evidence. They have the witnesses. They have the internet searches. But they also have to overcome the Supreme Court's ruling on jury instructions. They have to prove to a new jury that this was murder, not self-defense, and do it with proper legal instructions this time. Meanwhile, Giles is waiting. Thomas Cootie Jr.'s family is waiting. The children who witnessed the shooting are growing up with those memories. And Louisiana's legal system is deciding whether to retry a case that already consumed 9 days of trial, years of appeals, and a Supreme Court reversal. Justice delayed is justice denied, the saying goes. But what is justice in this case? A retrial? A plea bargain? Letting the reversal stand? Every answer leaves someone unsatisfied. Case 10, Jasmine Anderson. July 17, 2019. 1:40 p.m. Alexandria, Louisiana. Police dispatched to Christus St. Francis Cabrini Hospital. Jasmine Anderson, 24 years old, arrived with her deceased 5-year-old daughter, Audrey Cholette. Anderson claims the child was injured in a car accident. Investigators spend hours trying to locate the alleged crash scene. They find nothing. No evidence of a vehicle crash. When they eventually locate where the incident occurred, evidence indicates it was not a car accident at all. July 23rd. Anderson is located at a mental health facility in Bunkie. She's arrested and charged with second-degree murder. Bond set at $500,000. She's booked into Rapides Parish Detention Center at approximately 10:15 p.m. July 25th, 2 days later, Anderson is found unresponsive in her cell after a suicide attempt. She's declared clinically deceased at the hospital. The case ends there. No trial, no conviction, no answers. But the questions remain, especially when you look at the pattern. 2016. Christopher Dwayne Cholette, 20 years old, the father of Anderson's children, dies by hanging. Anderson finds the body. April 23, 2019. Christopher Dwayne Cholette Jr., 4 years old, Anderson's son, dies at Rapides Regional Hospital. Reported cause, choking on a bottle cap. Anderson finds him. July 17, 2019. Audrey Lynn Cholette, 5 years old, Anderson's daughter, dies. Victim's grandmother Kendra Foster observes, she was with them in their dying moments, all 3 of them, and none of them lived. Police indicate they would take another look at the prior deaths. But no public records indicate formal reopening before Anderson's death ends all investigations. Audrey's autopsy confirms a fatal neck injury. The grandmother reports observing a 4-inch slit on the child's throat with no other injuries consistent with a car crash. Anderson's story changes multiple times during questioning. Defense attorney Chad Guillot addresses mental health concerns after Anderson's death. Mental health issues are a problem among pretrial inmates. There are no services to assist them. They are simply put in jail and, sometimes, as in Jasmine's case, are not adequately protected from themselves. This case is different from our other 9 because it has no resolution, no trial, no conviction, no sentencing, just 3 deaths in 3 years, all connected to one woman. And that woman dying by suicide in jail 2 days after being arrested for the 3rd death. If Anderson killed Audrey, and the evidence suggests she did, why? If she killed her son Christopher Jr., and that's an open question, why? If she had anything to do with her children's father's death, and that's pure speculation, why? What could drive someone to potentially cause 3 deaths in 3 years? Mental health is the obvious answer. Guillot raises it in his statement after her death. Anderson was at a mental health facility when arrested. She was clearly struggling. But mental health explains behavior. It doesn't excuse it. And it doesn't bring back Christopher Cholette Jr., or Audrey Cholette. The justice system failed multiple times here. Failed to recognize a pattern after the first death. Failed to investigate thoroughly after the second death. Failed to protect Anderson from herself after the 3rd death. Now we're left with 4 dead people, unanswered questions, and a system that has to examine how a 24-year-old woman could be connected to 3 suspicious deaths before anyone acted decisively. Kendra Foster, the grandmother, lives with those questions. She lost her son, grandson, and granddaughter, all while the same woman was present, all while the system failed to connect the dots until it was too late. This is how our 10th case ends. Not with a verdict, but with a question mark. Not with justice, but with more deaths. Not with answers, but with grief that compounds every time someone asks why nobody stopped this sooner. 10 cases, 10 mothers, 10 different paths through Louisiana's criminal justice system. From life without parole to 18 months. From Supreme Court reversals to cold cases solved by DNA. From trials that ended in hours to investigations that spanned decades. From Shreveport to New Orleans. From Lake Charles to Alexandria. From Kenner to Natchitoches to Baton Rouge to Vinton. 6 cases resulted in completed sentencing. 2 await trial. 1 conviction was vacated by the Louisiana Supreme Court. 1 ended when the defendant died before trial. The investigative techniques range from traditional crime scene analysis to sophisticated DNA genealogy. Digital forensics cracked multiple cases: laptop searches, cyber tips, encrypted data, phone records, surveillance video. Community members played crucial roles: the neighbor who tried to save Shawburn Small, the truck driver who found King Trail Jack, the 200 mourners who attended baby Jane Doe's funeral. These cases reveal patterns. Prior criminal history matters: Thomas's earlier cruelty conviction, Small's abandonment conviction, Yates's theft arrests. Mental health crises appear repeatedly: Ferrand's struggles, Anderson's facility stay, the stress that led to catastrophic violence. Substance abuse plays a role: Jack's drug admission, Small's intoxication. And sometimes, as in the Perkins case, evil hides behind respectability. The sentences vary widely. Life without parole for Thomas and Perkins. 40 years for Ferrand. 30 years for Barker. 18 months for Yates. 5 years for Small after the Supreme Court reversed her life sentence. The justice system calibrates punishment based on intent, circumstances, prior history, mental health, whether the defendant directly inflicted harm, and countless other factors. The victims can't speak for themselves. Chase Thomas, 28 months old, 15 pounds. Galen Ferrand, 2 years old. Levi Ellerby, 6 months old. Blessing Buckles, 3 years old. Shawburn Small, 6 years old. Legend Jack, 4 years old. Baby Jane Doe, newborn. The juveniles victimized by Cynthia Perkins. Audrey Chalette, 5 years old. And potentially Christopher Chalette and Christopher Chalette Jr. if Anderson's other deaths are ever proven to be homicides. The children who survived carry scars. The 1-year-old placed in DCFS custody after his mother left him at a casino while other children killed his sister. The 1-year-old miracle baby who crawled near Interstate 10 for 2 days. The children who witnessed their mother shoot their father in a Walmart parking lot. The students who ate contaminated food from their teacher. The 7-year-old who escaped the fire while his sister died inside. This is crime unknown. These are Louisiana's cases. These are the stories that courts documented, prosecutors argued, juries decided, and judges sentenced. Some ended with closure. Some remain open. All ended with victims who deserved better. Remember their names: Chase, Galen, Levi, Blessing, Shawburn, Legend, Baby Jane Doe, Audrey. They were children. They trusted the adults who should have protected them. And those adults became the ones who destroyed them. When mothers become monsters, the system responds. Sometimes with life sentences. Sometimes with lesser punishments. Sometimes with reversals and retrials. Sometimes not at all. But the one constant across all 10 cases is this: the children are gone. And no sentence, no verdict, no legal proceeding will ever bring them back. Like, comment, and hit that subscribe button for more deep dives into the cases that shocked communities and challenged our understanding of what mothers are capable of when they betray the most fundamental duty any parent has: to protect their children. This has been Crime Unknown. Until next time.